Everyone, my name's Patty Ferguson Bonney, and on behalf of the Indian Legal Program, I'd like to welcome you to the 15th Annual Canby Lecture. I'd like to start by acknowledging that the law school is located on the lands of the Akimel O'odham, and that Arizona is home to 22 tribal nations that comprise 27% of the total land base. ASU acknowledges the sovereignty of these nations and is committed to scholarship, service, and teaching in the areas of Indian law and tribal law. Serving Indian communities, training Indian lawyers, and teaching Indian law has been part of the law school's mission since its founding. And this year, we're celebrating the anniversary of the Indian Legal Program, our 35th anniversary, and 56 years of the law school's commitment to Indian law, tribes, and Native students. This service of Indian country started when Judge Canby, our distinguished speaker tonight, and our named lecture series, was the first person to teach Indian law at ASU in 1967, 56 years ago. He laid the foundation along with support from the law school for our current program. This foundation set in motion the eventual formation of the Indian Legal Program. I'd like to thank you, Judge Canby, for all of your service to Indian country, to the law school, and the Indian Legal Program. And I'd like to acknowledge his wife, Jane, who's here, who's been a great supporter of the Indian Legal Program as well. Yes. I'd like to thank the community, our advisory council, alumni, students, faculty, and staff for your support and your presence. The ILP continues to focus on tribal law, and our hope is that we engage the community in a meaningful way. The ILP has over 400 alumni from 151 tribes who are making a positive impact in Indian country. We have 30 Native graduates who graduated before the formalization of the Indian Legal Program, and we've issued 175 Indian law certificates since 1988. We currently have 73 Indian Legal Program students. That includes 60 Native American students representing 38 tribes, and 40 of our ILP students are JD students. The backbone of our efforts are our dedicated staff and faculty. Our staff really have been working on our 35th anniversary, and we hope that you'll join us in some of our events. We have a CLE tomorrow, we have a dinner tomorrow night, and a golf tournament on Saturday. I'd like to recognize our executive director, Kate Rozier. She's in the back. And our program staff who have really been working hard to put together our program and our events this week. Danielle Williams, Teresa Beaulieu, and Lindsay Stevens. I don't know if y'all could raise your hands. I don't see you all, but there you are. Yes, thank you. And at this time, it's with great pleasure that I welcome our Dean, Stacy Leeds, to introduce our speaker. Stacy is a citizen of the Cherokee Nation, and she became the first Native American selected as a dean of a law school when she served as the University of Arkansas Law School dean. And we're honored that she joined our Indian Legal Program faculty and was selected as our dean of ASU Law earlier this year. She's the first Native American dean of our law school and the first Native American dean at ASU. So please join me in welcoming Dean Leeds.
Osio Nagad. Hello, everyone. We are so grateful to each of you for being a part of tonight's event and for helping us kick off this 35th anniversary celebration that we now go into. This will be the first event of our great weekend ahead, and we appreciate each of you for being here. I would also like to start out by welcoming our ASU Law alumni that are joining us for this weekend's activities. And it's also very special for us that we have so many of the clerks who have served in Judge Canby's chambers over the years with us tonight as well. So thank you for being with us. This is the 7th academic year that we've had the opportunity to work in this beautiful law school building here in downtown Phoenix. And I know walking into it every day that it's undoubtedly one of the most beautiful and welcoming law school buildings across the country. But it's not just the law school building and the physical space that distinguishes us from our peers. we are so fortunate to have grown and also sustained what undoubtedly is the nation's best Indian law program. And this has been a benefit not just to the Indian law program and the students in it, but it's also become part of ASU Law's core identity and brand. And the centrality of an Indian law program in the overall mission of a law school across our country just simply doesn't exist anywhere else. And I think that's one of the many reasons that this place is so special. I want to thank each of you who have been students, faculty, and staff here over the years who participated in the Indian legal program. I want to thank you for all your hard work, but I also want to extend thanks for all of the allies that are with us tonight that also made this possible. What is interesting is that when I joined the faculty, we were at the all-time high of the native faculty. There were 7 of us at that time. And you heard the statistics of how many students we now have across our many degree programs. And so it's really an amazing thing that in a 35-year window, the program has become a place that is not just an Indian law program, but the dream program for many future Native lawyers. And it also is a central part of just a law school that's made up of a student body of difference makers. The ILP's signature scholarly event each year is the Indian Legal Program's Canby Lecture Series. And in a quick moment of personal privilege, it was the Canby Lecture that first brought me to ASU Law when I was invited to give this lecture exactly 10 years ago, back in 2013. The Canby Lecture was initiated and it was originally funded by former Foundation professor Bob Clinton as a way of honoring Judge Canby. And while there are many reasons that we honor Judge Canby, this lecture first and primarily highlights the fact that he was pioneering in bringing the Indian law courses into this law school's curriculum. As a secondary matter, this lecture series also honors Judge Canby's many contributions to Indian country and finally his long and highly distinguished service to the bench and the bar. Now, as many ways that we carry forward Justice O'Connor's legacy in public service and community impact, I want to point out that Judge Canby has always been an ambassador for this law school and for our institutional priorities around public service and impact, and we greatly appreciate this. In this special year for ILP, in our reflection and also in our celebration, we are so honored to have Judge William C. Canby Jr. himself deliver this lecture. Judge Canby is a graduate of Yale University and the University of Minnesota School of Law, and he began his legal career in public service as an Air Force JAG officer before clerking for Justice Whittaker on the United States Supreme Court. During his tenure as a law clerk, he also was part of the court that issued the notorious Williams versus Lee decision, and it was that case that sparked a lifelong interest in Indian law in him. He then returned home to his home state of Minnesota and entered into private practice, and then Judge Canby and his wife Jane, which I'm happy that you're here today with us as well, they helped establish together the Peace Corps in Africa, serving first in Ethiopia, and then he served as the director in Uganda, where he would later go back as a faculty member on a Fulbright scholarship. To our collective great fortune, Judge Canby came to Arizona in 1967 as a founding faculty member here at ASU Law, where he taught all across the curriculum with a small faculty that taught many, many, many classes. But it was during this time that he also taught the first classes in Indian law and really championed the creation of what we know today as the Indian Legal Program. He also devoted during this time numerous hours to assisting Arizona farm workers and other citizens that were in need of legal assistance. In 1980, President Jimmy Carter appointed Judge Canby to the United States Court of Appeals for the Ninth Circuit. He is an elected member of the American Law Institute and is nationally regarded as both a professor and a jurist with expertise in American Indian law and constitutional law. In addition to a very large body of judicial decisions and scholarly works, every Indian law student, practitioner, and educator has a very well-worn copy of the Canby American Indian Law Nutshell on their shelf, and that publication is now in its 8th edition. Perhaps the most important, though, of Judge Canby's legacies are the countless students and lawyers that he mentored over the years and supported. And that includes the hands-on recruitment across many reservations in Arizona during the early years, which led to some of ASU's first native law graduates. So with that, if you will join me in an initial round of applause as Judge Canby makes his way to the podium. Thank you.
Well, thank you, Patty, and thank you, Dean Leeds, for your kind words. And it makes me think of the old days when Patty mentioned a small faculty. There were 6 of us, and we could hold a faculty meeting around one small table in a coffee shop, which we often did. It's become quite an institution since then. The only other observation I have is outside, one of the students asked me, well, are you going to start with a joke? And I said, well, I don't think that's really appropriate, but I could observe what I said to somebody out in the lobby, and that is that I now sit back and enjoy watching a couple of younger men jockeying to be President of the United States. The presumptuous title of my talk is Indian Law Today, Tomorrow from a Long-Term Perspective. And that's such a huge subject that we could never end it if I explored every corner of it. What I'm going to do instead is concentrate on a couple of themes in Indian law and some very recent Supreme Court cases that tangle with the problems that Indian law still presents and the new perspectives that face the court when they deal with those problems. I don't know that I have to set the scene for this audience, but all of us who work in Indian law and spend all our time just kind of thinking about it, remember the basics in the beginning. All Indian law, I've often said, depends more on an understanding of history than almost any other subject. Yeah, and it all starts really back before the Revolution, when the tribes were independent nations. They were here, the Europeans arrived, and mostly it was the British that were administering where we are, or where at least all of the eastern colonies were. And they found that the colonies were so mistreating the Indians and grabbing their land and everything else that it was causing a lot of Indian wars, which the Crown then had to send troops to fight. So the Crown decided that we're going to have to be the ones who decide matters of Indian policy and Indian law. We will decide how Indian tribes will be treated by the non-Indian governments. And then when the Revolution came, the same considerations entered the picture, because after the Revolution, the weak federal government didn't really have the resources to fight Indian wars, and there's a famous letter from Secretary of War Knox to Washington saying, we're in no position to fight Indian tribes. Don't let the states take over Indian law matters. It's got to stay federal, and that's the way it was. It did stay federal. The Constitution, of course, as we all know, gave Congress the power to regulate commerce with the Indian tribes. And commerce was understood in that context to include all relations of any kind. In other words, we'd call it Indian affairs, probably. it wasn't just trade. Everybody understood that it was anything that tribes and the government had to do with each other was covered by Congress's power if Congress chose to intervene. And then we, of course, on the legal side, we had John Marshall, not John Morris, my old colleague, John Marshall in charge of the Supreme Court, and he was a Federalist, and he was certainly wanted continuing federal control, and he was became quite respectful of tribal sovereignty. And so we had him in the second big case came to the Supreme Court, Cherokee Nation against Georgia. He said, well, these are nations. You know, they're just like, we deal with them just like other nations, except, of course, they're encompassed within the territory of the United States. So they're domestic dependent nations, but they're nations. And then a year later, he gets another case and he said, Georgia was trying to obliterate the Cherokee government. And he stopped that and said, the Cherokees have an independent nation dependent on only the United States, independent otherwise, and set in clear boundaries in which the law of Georgia can have no force. And all of us, that's been kind of the mantra of everybody that dealt in Indian law ever since. The ones who want the tribes to have maximum protection from encroachment always look to the federal government to manage things in ways that the states could be prevented from interfering with the tribes. Well, that's background that a lot of you know, and I'm probably boring some of you with it, but it's what we kind of have as our background when we talk about Indian sovereignty. And Indian sovereignty is very much a subject to some of the cases I'm going to talk about. I'll pick 2 or 3 of the recent cases, and there's no better case to start with for a look at the court's view of federal power over Indian affairs than the Indian Child Welfare Act case, Brackeen, Holland against Brackeen, that came down just this year. The case arose because Congress was asked to act upon a problem the tribes had, and it got to be a very severe problem. And that is, so many of their children were being either adopted away or placed in foster homes that were away and non-Indian, that the tribes were losing a considerable percentage of their kids. And some tribes estimated 25 to 35% of their kids were being taken away from the tribal parents and from the tribal surroundings. And they looked at that and said, there's not going to, a few years of this, a few decades of this, there's not going to be enough left of our tribes to maintain a reasonable existence and to pass what we know are our legends and our understandings and our stories on to a younger generation. They won't understand what the tribe is all about because they're gone. So they kept telling Congress something has to be done. Congress finally acted in 1978, and they responded in a big way. The Indian Child Welfare Act intervened very greatly in how adoptions and foster placements and everything else could be achieved if they involved Indian children. It's, I can give you a few ideas of the act. That first, most of these adoptions occur in state court. Some perhaps could come through tribal court, but typically it was non-Indian parents going to state court to adopt an Indian child. Well, the legislation wanted to regulate that, so it starts with adoption or foster placement of an Indian child. What's an Indian child? A member of a federally recognized tribe or a child who is eligible for membership, even though not yet a member, and is a child of a member of a recognized tribe. That's an Indian child. Well, if an Indian child, if somebody seeks to adopt an Indian child, or just to adopt a child in state court under this act, if there is any reason to think the child might be an Indian child, there are burdens of inquiry placed on the state court. You've got to find out. You can't just say, well, this doesn't look like an Indian child to me. You've got to inquire and pursue and see whether that child is an Indian child. If the child is an Indian child, there are strict standards on where the adoption can go or where the foster placement can be made. And this isn't something that is advisable. Unless the court finds there is good cause, and that's a legal term that requires quite a substantial showing, as it has turned out. Unless there's good cause, Indian child up for adoption has to be adopted in order of preference by a member of the child's extended family, or in the second, if that's not available, other members of the child's tribe, or if that's not available, other Indian families. And only if none of those are available is this non-Indian adopting parent able to adopt the Indian child. Those preferences come first. And the same with foster care placement. The first preference for foster care placement is in the extended family of that Indian child. Failing that, it goes to tribally approved foster institutions. Failing that, it goes to other Indian-connected institutions that are approved by the state. And that's it. You can't really just come in and act as if an Indian child is just one more child to be placed. The problem of foster placement, in other words, placements where the state has actually intervened in the family. Nobody's coming to adopt yet, but you can understand what might happen. A social worker from New York City, or even maybe Phoenix, goes up to a Hogan on the Navajo reservation. It's a nice day. Parents are inside. The kids are out running around in the yard, little ones with no diapers, probably maybe barefoot. And then they inquire of the people in the house, do you have running water? No. Do you have electricity? No. Well, what's your floor made of? Well, it's dirt floor. We got some carpets on it. These kids are neglected. How can any kids live like this? So they better be taken away and placed in a state foster home where they'll be raised in much better conditions than this. Well, of course, they're breaking up a family that nobody's neglected. And that's what was happening before the Indian Child Welfare Act came along. Well, you can see what happens and how wrenching these cases can be. In the Brackeen case, the adoptive parents were, well, I'll start with the children. The child, will be children, the child was placed at age 10 months in a foster home. The background isn't clear on what caused that, but it was voluntary. The mother placed it there. After about a year, the foster parents wanted to adopt that young child. The mother and the father and the grandmother of the child thought this was a great idea. The foster parents have been very good with this child. They've had it for a year and everything else. So it's okay with us. All the parties were there, but the tribe had to be notified under the Child Welfare Act. The tribe objected, and that stopped the adoption. As time went on, the tribe offered some Indian families, not related, not part of the extended family, that they thought could adopt this child. As time went on, those families kind of begged off and said, no, we really don't want to do that. So the tribe finally said, okay, we can't find anybody. And they backed off, and the adoption went through. The Brackeens actually got to adopt that child. Their case didn't become moot because they next wanted to adopt that child's older sister, and the tribe was objecting. So the case went forward, and the Brackeens came with two attacks. One, this is beyond the power of Congress. This isn't regulating commerce with the Indian tribes. Even broadly construed, how can they interfere with something like, a child adoption? Typically, federal courts don't have any family law power. I can conduct a marriage because the state of Arizona lets me do it. Nothing about being a federal judge permits me to do that. The federal courts don't have anything to do with, basically, divorce, marriage, family law generally. So how can the Congress intervene in this? Well, that's question number one. Question number two was, does it violate equal protection to say that this child has to be adopted by an Indian family when that discriminates against me as a non-Indian who wants to adopt this child? So what happens when the court gets the case? Justice Barrett wrote an opinion, and she said, well, let's first look at whether Congress has the power to do this under the Indian Commerce Clause. And she said, I can look up 50 cases or 100 cases where somebody has come in and said, well, Congress is messing with Indian affairs and it doesn't have any power to do this. And every time the court just says, well, now wait a minute, Congress's power over Indian affairs is plenary. And then they cite some other case saying, Congress's power over Indian affairs is plenary. Plenary meaning complete, total, so on. But they don't really explain why it's plenary or what boundaries, if any, there are to plenary power. So Justice Barrett and her majority, which consisted of the so-called, at that time, a liberal bloc of Ginsburg, Breyer, and Sotomayor, and Kagan, joined her opinion. And she said about these cases that just said, well, this is within the plenary power of Congress. And up to then, I had really not read any cases that talked about plenary power that didn't find Congress had the power. All of them said, oh, this is Indian affairs, Congress can do it. And she is trying to say that we can't be this sloppy about plenary power. And she says, for instance, to be clear, plenary does not mean free-floating. A power unmoored from the Constitution would lack both justification and limits. So like the rest of its legislative powers, Congress's authority to regulate Indians must derive from the Constitution, not the atmosphere. She later, in her opinion, says, Article 1 gives Congress a series of enumerated powers, not a series of blank checks. Thus, we reiterate that Congress's authority to legislate with respect to Indians is not unbounded. It's plenary within its sphere, but even a sizable sphere has borders. Well, what's she going to do? In fact, she says this is well within Congress's power over Indian affairs. The problems of the children being taken away from tribes interfered with the government-to-government relationship between the tribes and the Indian nations. There won't be anything left of the Indian nations if this adoption and foster placement system goes on as it has in the past. So Congress has the power to do this. We're left, though, with no explanation of what other boundaries there might be to plenary power of Congress. And the fact that she's made these statements kind of leaves an open question. When is something going to be found that deals with Indian affairs that is not within Congress's power, just as a matter of the source of power being in the Constitution? Well, we don't have to answer that question. She finds the Indian Child Welfare Act is within Congress's commerce power. She doesn't get to the equal protection question, and I'll come back to that in a minute, because nobody before the court had actually had their equal protection rights denied or arguably denied. So she says nobody had standing. Under the circumstances of this case, nobody had standing to bring the equal protection challenge. That's not what's really involved so far. So we don't have to rule on that. Justice Gorsuch, having joined the majority opinion, and we're going to hear a lot about Justice Gorsuch in the next minutes, wrote a lengthy concurring opinion, and he weighs in on the subject of plenary power. But first, he lays out, and he does what he often does on the court. He said, let me tell you about the Indian experience in the past that leads us to where we are deciding this case today. And he said, look, the adoption business that was going on in the early 20th century and right up to the time the act was passed, and probably to some degree even after, that isn't new. There was a huge, strong federal policy in the last half of the 19th century to wean all tribal children away from their tribes. And they did it by establishing boarding schools. The boarding schools were not on the reservation. They were taken to places like the one up on Indian School Road here in Phoenix. They would get the child there and sometimes force the child there. And there, they would cut the child's hair, put the child in Western clothes, and make them look like non-Indians and act like non-Indians. And they would be punished if they spoke their tribal languages. They had to speak English. The purpose of that federal policy was to drive the Indianness out of the children when they went back to the tribes, then they really wouldn't fit in, and the tribes would be no different from the rest of society, according to our federal policymakers in the 1970s, 80s, 90s. And he says that's what was going on. So don't think that this was all just kind of an accident that came out of the blue, that everybody suddenly wanted to adopt Indian children. It was a policy. But then he goes on to talk about plenary power. He has a different beef. He's happy to see the majority opinion emphasize that the plenary power has limits, because he thinks plenary power took a wrong turn in the 1880s by having Congress interfere with the tribes. He said the first thing that went wrong was the Federal Major Crimes Act. The Indian tribes, up until the 1880s, did all the policing within their own boundaries. They took care of crimes by their own members, against their own members. There were tribes in the North Plains where there was a murder, and a little later there was a kind of a retaliatory murder. And of course, the Indians' response to a murderer was totally uncivilized. Instead of just executing the murderer, they required compensation, livestock, and other kinds of wealth to be paid to the victim by the perpetrator. And the perpetrator would have to understand that he or she had broken the fabric of the tribal culture and it would need to be rehabilitated. And that's obviously uncivilized. They should have just killed them. At least that was the federal view of it. So they passed the Major Crimes Act, saying that any Indian in Indian country who commits any of the, it was then 7, now it's about 13 or 14, major crimes, would be subject to federal prosecution, not state, just federal prosecution. Well, that was the first federal incursion into the internal affairs of the tribes, and that's what's irritating Justice Gorsuch about plenary power. He said, when you talk about plenary power, it's a two-edged sword. It can be used against the tribes as well as to protect the tribes. In the case of the Indian Child Welfare Act, it's being used to protect the tribes, but he's glad to see all this talk about limiting plenary power because he has hopes. He winds up expressing his hopes for the future, and he wants the majority to develop its idea of plenary power to keep the federal government from interfering in tribal matters. Well, he says, I should maybe read his closing. He says, to resolve the present dispute, the court understandably sees no need to demarcate these limitations further, but I hope that in time it will follow the implications of today's decision where they lead and return us to the original bargain struck in the Constitution, and with it, the respect for Indian sovereignty it entails. Well, where do we think plenary power will go in view of in these two views on the court? Each with some support from other justices. It's clear that Justice Barrett and Justice Gorsuch are in favor of limiting plenary power, but about what? And which way is this going to go? Which way are future efforts of the court going to go in finding limits to plenary power? In this one, I think I'd have to bet on Justice Barrett's view that the first limits on plenary power are likely to be found when that power is being used in ways that are challenged by non-Indians. Gorsuch's view is plenary power will be limited when it tries to intrude on tribal matters. And I think for historical reasons and just by counting numbers, probably the next cases, the ones that might be called upon to limit power, may well be attacks on some of the classifications in the Indian Child Welfare Act that the equal protection issues that the court didn't have to get to because it wasn't before it. And I want to then get to a new twist on the Brackian case. Justice Kavanaugh wrote a brief concurring opinion, and first he fully joined Justice Barrett's opinion. And he repeats the fact that we don't reach the equal protection issue because nobody has standing. He said, and he's, I'll quote, "So the equal protection issue remains undecided because nobody has standing to raise it." He then offers his own preliminary view of this issue. I'm quoting now because this is a very strange opinion. "In my view, the equal protection issue is serious. Under the Act, a child in foster care or adoption proceedings may in some cases be denied a particular placement because of the child's race, even if the placement is otherwise determined to be in the child's best interests. And a prospective foster or adoptive parent may in some cases be denied the opportunity to foster or adopt a child because of the prospective parent's race. Those scenarios raise significant questions under bedrock equal protection principles and this court's precedents. Courts, including ultimately this court, will be able to address the equal protection issue when it is properly raised by a plaintiff with standing. For example, a prospective foster or adoptive parent, or a child in a case arising out of a state court foster care or adoption proceeding." And of course, it'll go up through the state courts, and then they can try to get to the Supreme Court. Now, this concurrence is really breathtaking. In the first place, he's just joined an opinion and repeated that the issue is not before us. And then he goes ahead and gives us it obviously is a tilted attitude toward how the issue should be resolved. The second, and even more jolting, is the assumption that the distinction between Indians and non-Indians is a question of race. 50 years ago, the Supreme Court addressed that question. There was an employment preference for Indians for employment in the Bureau of Indian Affairs. It went to the Supreme Court in a case called Morton against Moncari. Justice Blackmun wrote the opinion, and he said, this is not a racial preference. The preference is not for anybody who is Indian in an ethnic sense. It's a preference for members of recognized federal tribes. It is therefore a political category. There's a government-to-government relationship between tribes and the United States, and the United States in hiring can favor, as a political matter, members of recognized tribes, and that is not a racial category subject to suspect, highly, a really heightened standard of review under equal protection analysis. It's just a rational basis review. And he says, well, it's rational for the government to think that it's good to have some of the group that's being regulated in the management of the agency that is charged with regulating Indian affairs, the Bureau of Indian Affairs. Well, Justice Kavanaugh may not understand the distinction between a racial category and a member of a federally recognized tribe category, but the Indian Child Welfare Act is written in terms of federally recognized tribes. The child has to either be a member or eligible for membership in a federally recognized tribe. The preferences for extended family and for even other Indian families are matters of recognition. Indian is defined, tribe is defined, and the Indian that's defined as member or eligible for membership in a federally recognized tribe. Tribe is defined as a federally recognized tribe. So the category is not racial by the existing Supreme Court precedent. And Gorsuch is writing, Kavanaugh is writing for himself. But he leaves, of course, a roadmap for the next case. He even says who'd be a good plaintiff in the next case. And it's a startling performance. And perhaps when the case comes up, if he has time, when it's really in front of him, it will be adequately briefed and somebody will explain the difference between the political category of member of a recognized tribe and the racial category, if it is racial, or ethnic category of Indians and whites. There is some education that the rest of the court and the counsel appearing before the court are charged with, and that's to perhaps get to Justice Kavanaugh on the subject matter that he's forced to deal with from time to time. Justice Gorsuch, I really need to say something about, because he's a new force on the court, and he's a pretty strong wind. He came from the 10th Circuit, where he had much contact with Indian law. Everybody else on the court practically comes from, an Eastern elite law school or something like that. And he's one of the few people who came from the West. He came from the 10th Circuit, which is, New Mexico and places around Colorado, places like that. A couple of years after he reached the Supreme Court, he voted with 4 other justices to construe a treaty which provided that the Yakima Indians in Washington had the right, this is a treaty clause, quote, the right in common with citizens of the United States to travel upon all public highways. The court held that that included the right to put cargo, your goods on, to buy cargo and bring it into the reservation, to produce cargo and take it out of the reservation without it being able to be taxed in transit by the state of Washington. And the court went for the tribe, and the analogy was the fishing cases, the Washington fishing cases authorized the tribal members to fish on the accustomed stations off reservation in common with the citizens of the territory. Well, the question came up, the territory would say, well, that means they got to get by a license and have the same limits that apply to everybody else. But they have a treaty, it's different. And they get to have privileges and rights beyond what the average citizen has, because it's a treaty right. Justice Gorsuch in this case with the Yakimas, the chief, I should say, for detour a minute, the Chief Justice and a few others said, well, this is really just a tax on property, and they tax the same property if it's not on a truck to and from the reservations. But Justice Gorsuch joined the group that said, no, this burdens the transportation of goods. And that's what the treaty was really guaranteeing. It wasn't just that the members of the tribe wanted to travel to Seattle to look at the sites. They were in trade at the time. And they had goods that they made, and they traded, and they trucked them to and from the reservation. But he said, in talking about the treaty, why did Washington guarantee access of Yakima goods to the outside world? Well, he said, quote, he's talking about the treaty negotiations. In fact, the millions of acres the tribe ceded, giving away a lot of their land for development, were a prize the United States desperately wanted to settle titles for settlers flooding into the territory. The Yakimas knew all this and could see the writing on the wall. One way or another, their land would be taken. If they managed to extract from the negotiations a simple right to take their goods freely to and from the market on the public highways, it was a price the United States was more than willing to pay. By any fair measure, it was a bargain basement deal. He then winds up the language with a tone we see in his other cases, and I quote Justice Gorsuch again. Really, this case just tells an old and familiar story. The state of Washington includes millions of acres that the Yakimas ceded to the United States under significant pressure. In return, the government supplied a handful of modest promises. The state is now dissatisfied with the consequences of one of those promises. It is a new day, and now it wants more. But today, and to its credit, the court holds the parties to the terms of their deal. It's the least we can do. It's the end of his statement. And that's a really remarkable statement. He's fresh to the court, and that's what turns out to be his notice about what's going to interest him from now on while he's on the court. Well, Justice Gorsuch is, however, much more famous for the bomb he dropped into Oklahoma. And that has to do with a case called McGirt. It's McGirt against Oklahoma. And it was decided 3 years ago. It's hard to set the scene for Oklahoma if you're used to dealing with all other areas of Indian law, because Oklahoma was assumed to have a completely different setup from all the other states. It was regularly thought for the last 110 years that there was no Indian country in Oklahoma. There were no reservations in Oklahoma except a subsurface reservation for the Osage, oil rights, but no surface rights. And the Oklahoma state courts treated Indians exactly as they treated all the rest of the Oklahomans. They were subject to the state criminal law. They were tried in the state courts. They could be convicted in the state courts. And there was virtually no employment of the Major Crimes Act because there was thought to be no Indian country for the crime to be committed in. Well, how did it get that way? And of course, you have to go back in history to the so-called Trail of Tears, but the 5 civilized tribes, and I'll call them that for right now because that's what they were called by everybody. Congress passed all kinds of statutes that refer to the 5 civilized tribes. And the 5 civilized tribes were the Cherokees, the Chickasaws, the Choctaws, the Seminoles, and the Creeks. And they were in the Northeast. I think probably you're all familiar with the story. in Indian removal. They were moved to the west in the area around Oklahoma, which was then just called the Indian Territory. And there were numbers of treaties that they got along the way, promising, well, when you get to the Indian country, this will be your land. It'll never be placed within a state. It will never, you will never have state government interfering in your affairs, and things like that. And Justice Gorsuch gets a hold of this case. The way it arose was McGirt had committed a very serious crime against, it was a child molestation crime, and it was against an Indian, and he was, I'm sorry, I'll take that back. He was an Indian. He was a Seminole. The crime was against a child, a foster child. And he was tried in Oklahoma court. He was sentenced to what amounts to life in prison. And he brought a very original case. He brought a habeas corpus case in federal court saying, I'm in prison in Oklahoma and I'm an Indian and I committed my crime on the Creek Reservation. And therefore, the state had no jurisdiction to try me for my crime. The federal district court rejected that. It got to the 10th Circuit, and the 10th Circuit listened and said, no, well, we are not convinced that the Old Creek Reservation was ever disestablished. Well, the Supreme Court took cert from that case. There was one other like it that they also took. So it gets up to the Supreme Court, and many of us who had for years, and this includes me, said, well, Oklahoma's different, there's no Indian country in Arizona. We're kind of waiting for this case to come down, and we wondered, well, what's taking them so long? They held the case for a long, long time, and they put it over to a new session of the court, perhaps waiting for one more justice. There were only 8 at the time they put it over. And then the case finally came out, and Justice Gorsuch wrote an opinion saying the Creek Reservation was never disestablished. It still exists where it did. That's Indian country. Where this crime was committed was Indian country. The state had no jurisdiction to try him. Well, what was it that caused a lot of the government, virtually everybody in Oklahoma, and certainly the Oklahoma authorities, to think that Oklahoma could deal with the Creeks as having no Indian country and being subject to Oklahoma criminal laws? Well, after the Civil War, the Creeks in the United States entered a treaty in 1866 by which land was set aside as a home for the tribe. A large influx of non-Indians followed. By an agreement in 1901, well, let me back up a little. The Creeks did have a designated territory. And it had boundaries. So there are, geographical places you can find if you're arguing about does the Creek Reservation still exist? We know what those boundaries would be if it does still exist. And by an agreement in 1901, the lands which were owned by the Creek tribe in fee simple. This is really different from most reservations. Most reservations, the United States owns bare title in trust for the tribe. So the beneficial owner is the tribe. Take the Navajo Reservation or Gila River or out nearby. Those reservations are held in trust. The owner is the United States. The beneficial owner is the tribe. But in the Creek Reservation, when it started, was different. The tribe itself was the owner in fee simple, but it was communal ownership. It wasn't individual. It was in the hands of the tribe. By an agreement in 1901, the lands owned by the Creek tribe were all distributed in allotments to members of the tribe. Those allotments went out of trust in time, and they were then subject to taxation by the state. They could be bought and sold, and a lot of them were sold for taxes. Creeks who got this land probably couldn't pay taxes on them. Many of them had to sell the land for a pittance in order to get money to live on. So that land just got dissipated, and ownership was largely lost to the Creeks, who originally had each gotten a fee simple title to a plot of that land. Also in 1901, Congress made all of the 5 tribes members United States citizens. Most Indians in the country at that time, tribal Indians on reservations, were not citizens. It wasn't until 1924 that there was a general citizenship act that was passed. So the 5 tribes were treated differently. Meanwhile, Congress had provided that the federal territorial court would exercise jurisdiction. This is about the same time as the distribution of the land. But they said the territorial court would exercise jurisdiction and apply the laws of the United States and Arkansas to all persons irrespective of race. What the territorial court did during the time when they were administering all this Indian territory was apply federal law to the extent that it applied in terms. And then if a state law issue came up, they would apply the law of Arkansas, which was the nearest state to the east that had reached statehood, and they would use Arkansas law. But once the Congress had told them, apply the laws of the United States and Arkansas to all persons irrespective of race, that meant that the territorial court would apply Arkansas law to Indians and federal law if it was a federal issue. In 1898, Congress abolished all tribal courts in the Indian Territory. Statehood for Oklahoma followed in 1907. Cases under that law, cases in the territorial court that arose under federal law were sent to the new federal court. Cases in state court, cases in the territorial court governed by Arkansas state law were sent to the new Oklahoma state courts. Well, you can see where we're going here. The courts of Oklahoma simply stepped in and started adjudicating cases rising from the 5 civilized tribes, the same as they were adjudicating every other case they had, and this went on for 100 years. I might add a word on we talk sometimes of the 5 tribes and the 5 civilized tribes. They were originally called the 5 civilized tribes. There were statutes calling them the 5 civilized tribes. they were called the civilized tribes, as far as we can tell, because in the East they had settled down into farming, and they occupied themselves with farming in much the same way as the non-Indians nearby did. And that seemed to those among them to be civilized behavior. The Cherokees had even developed a written language. So they were called the civilized tribes. I used to tell my classes with my tongue in cheek that the reason they were called the 5 civilized tribes by their white neighbors was that several of them owned slaves. And that had to be a mark of civilization, if nothing else was. Anyway, that's why we call them the 5 civilized tribes. I think that has made the court nervous lately. And you'll find that all the cases after about a decade ago call them the 5 tribes. And everybody knows what we're talking about when we say the 5 tribes. It's capitalized, the 5 tribes. It's the same 5 civilized tribes I was talking about before. Well, now comes McGirt against Oklahoma, and I've said what he was claiming. Justice Gorsuch, joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan, held that the Creek Reservation, where McGirt's crimes had occurred, had never been disestablished. So it's still Indian country. The way that Justice Gorsuch approaches this is to say that if Congress is going to disestablish a reservation, it has to be very, very clear about what it's trying to do. And we look for the words to tell the intent of Congress. And we don't require a particular word to say, they don't always have to say the reservation is disestablished, but they have to make it clear that they're intending to abolish the reservation. And some words like the land is returned to the public domain, or the land is being sold and the proceeds are divided among the members of the tribe, and the reservation, is gone. It's part of the public domain, things like that. And he looked for it and he didn't find it. He found the history I've just repeated of those things going on, but he said, none of them stop and say anything about disestablishing the reservation. It's true that there was a statute winding up the Creek tribe's affairs and putting them in the hands of a group that was, winding up those affairs and reporting, distributing the last of the tribe's assets to individuals of the tribe. But they didn't say that the reservation was disestablished. Up to this time, when they got cases of disestablishment, the Supreme Court had a kind of a 3-part test. The case of Solem against Bartlett, it's a couple of decades before this time. And it said, to see whether a reservation has been disestablished, we look into 3 things. First, the language. Does the language indicate that Congress disestablished? If they say the land was for sale and proceeds were given to the Indians who previously inhabited it, that's a good sign. But no particular words of disestablishment are required. The next thing we look at, if we're not sure what the words said, was the common understanding of the parties to the agreement, to the extent you can tell what those were. If there's evidence, if there's a record of what they were, what were the parties' postures at the time? What did they think? There's quite a lot of history saying that the parties thought the ball game was over, that they were being turned over to the state. That's not, that may not have been freely given on one side, but there are numbers of statements where leaders of the Cherokees would talk about their former reservation. And then the third thing that Solem said was subsequent developments, including, but perhaps least important, the further population of the area. And of course, here, the population of the area has become overwhelmingly non-Indian. It is true that under that three-part test, that was the least important part, because a lot of reservations were allotted and but held in kind of a checkerboard situation, and the reservation boundaries weren't changed, and they didn't just establish a reservation. There are a lot of reservations where non-Indians, especially in the Midwest, are heavily checkerboarded into the reservation. But Justice Gorsuch says, in his opinion, if we can't find in the statute words evidencing Congress's intent to disestablish, we don't go to the next two bits of evidence to look at: the posture of the parties and the nature of the negotiations, or subsequent events and how things were treated, maybe even by the parties to the negotiation. We don't get there. Well, this is kind of a literalist view. We're looking for words in the statute saying that the reservation still exists. Or what we're really looking for is some affirmative indication that the reservation which did exist has been disestablished. Some words that affect that disestablishment. And if we don't see that, we don't go on. The Chief Justice and the other justices who dissented picked up on this and said, you're not following our usual pattern of determining whether a reservation has been disestablished. And then they recite some of the things I did about what was going on at the time of statehood. When I look at this, as a matter of pure statutory interpretation, stepping back from maybe even an Indian law posture, what was it that Congress was trying to do over the period of these statutes creating statehood? I think the chances are awfully high that Congress wasn't trying to preserve anybody's reservation. I don't think the attitude of Congress was very good at that time, and I know Justice Gorsuch thinks it was clearly the wrong attitude. But as an exercise in figuring out what Congress really intended, I think the evidence tilts pretty heavily the other way. I don't think Congress was feeling very charitable. When you have a literal requirement, it can dislodge some of the more normal ways of interpreting intent. So I think McGirt probably doesn't really reach what Congress intended. But now you can argue that the other way. If Congress somehow intended the reservation to continue even though all the affairs of the tribe had been wrapped up, but I would say that the evidence leans the other way. of course, the deed is done, and it was a great victory for tribal sovereignty. There's no question about that. All of a sudden, 43% of Oklahoma is Indian country. Well, Justice Gorsuch did take the opportunity, and he does when he can, to tell the story of how the Indians have been mistreated. And he goes through the Trail of Tears. He talks about all the promises that were made by treaties. He acknowledges those treaties were replaced by later treaties or by statute, but there were broken promises nevertheless. Contrary to what a person in the street might believe, a treaty doesn't have any special status beyond that of a statute. I mean, the United States can make a treaty with, to pick a nation out of the air, Russia, and the United States the next day can decide to break that treaty, just abrogate it, say we're not going to abide by it. That may violate some sort of international law out there, and somebody can take umbrage at it, but for domestic purposes, if Congress abrogates that treaty, the treaty does not exist as part of American law anymore, just as a statute can be repealed by a later Congress. A treaty can be repealed. Legally, that doesn't mean it's a good thing or it's an honorable thing. And I think that's what Justice Gorsuch is. He admits these treaties have been superseded by subsequent treaties and things. But he said those were still broken promises. And that informs his whole opinion. And he goes at great length into the history, all those broken promises. And he makes the court aware of them. And he makes the reader aware of them. And it puts kind of a new perspective on things. It doesn't give the Creeks their land back. Finding that all of 43% of Oklahoma to be Indian country doesn't give a square foot of land back to any Indian in the 5 tribes. It does, however, amount to more than a conceptual victory. It is a conceptual victory. It means the tribes are still sovereign. There still is a reservation. There still are tribes. The tribes didn't disappear. And they've got some lands here and there. They don't have the old reservations. But now they have a reservation. Now they don't own almost all of it. They own very little of it. So where's the victory? Well, there's several. One, it is conceptual. The court has actually recognized, that we had a territory, and we still, at least in concept, have that territory, and that involves some jurisdiction we can talk about in a minute. It also opens up a few things in the distant future. If the tribe can amass resources and buy some land in that old reservation, they can petition the Secretary of Interior to take the land into trust and hold it for the benefit of the tribe. Other tribes have done this with selected little plots of land, and in the last several decades, the Secretary of the Interior has taken hundreds of thousands of acres back into trust. Now, a lot of that, in fact, was from existing federal lands. It might be Bureau of Land Management land or something like that. But some of it was tribal land that had been purchased by tribes in their old, historic territory, and the Secretary has taken it into trust. Or it's often bordering an existing reservation or filling a hole, non-Indian ownership within an existing reservation. And the tribe acquires the title by purchase, and the Secretary takes it back into trust. If the Creeks and the other tribes can do that and expand their actually owned territory within the reservation. It offers a stable platform for their own government for future operations of the tribe. And I don't know what the gaming situation is, but I do note that the Indian Gaming Regulatory Act requires Indian gaming to be on Indian lands. And you begin to wonder what kinds of lands might be taken into ownership, and would there be a possibility of getting compacts for gaming? I don't know. I haven't looked into the gaming situation in Oklahoma, but that certainly has to come to a mind of anybody who deals with Indian gaming today. Now for Oklahoma, McGirt created all kinds of problems. First place, they've got thousands of defendants who were Indians who committed crimes in what we now know, and Oklahoma has admitted, and its courts have ruled, that what Gorsuch said goes for the Creeks goes for all 5 tribes, because the history is exactly the same. All the same things were done to those tribes. So you've got, that's what gets you up to 43% of Oklahoma. And that means there are lots and lots of convictions, either of Indians that normally in Indian country can't be convicted by the state, or of non-Indians who have committed crimes against Indians, which up to that time were thought to be exclusively federal if it occurred in Indian country. And that's a huge number of convictions. And the state read McGirt and starts granting habeas corpus and delivering these prisoners up. And they can be retried. Most of the, if they're Indians, or even if they're non-Indians who committed a crime against an Indian, they can be tried. If it's a major crime, they can be tried in federal court. If it's a minor crime, they can be retried in tribal court. Of course, if somebody was convicted 50 years ago and sent to a long term in an Oklahoma prison and need to be retried today, you may have a little trouble finding the witnesses. You may have a lot of trouble. There may or may not be a good transcript of the trial. And if you could find the witnesses, they might not even remember what they saw or what they testified to. So that creates a considerable problem. The flood that occurred when that happened, some of the people here, I know, at least certainly one of my clerks I know is here, and others are here probably who work for the federal defender in Arizona. A lot of those cases, if they were major crimes like McGirt's, could be dumped on the federal courts. But the U.S. Attorney was overwhelmed with all these cases coming out of the Oklahoma prisons. And the federal defender had to defend all those cases. So the federal defenders here in Arizona have spent quite a lot of the last several months, a couple of years, in Oklahoma, an extended duty, just dealing with the cases that came out of this. That's a practical problem. It wasn't a permanent problem in the sense that what McGirt did was restore Oklahoma to a position that is no different really than Arizona. In other words, there's Indian country here, and cases in Indian country crimes by Indians either go to tribal courts or federal courts. That's true here. When non-Indians attack Indians and vice versa, those go to federal court, or at least they did 3 years ago. So it wasn't as if Gorsuch's opinion suddenly created a new creature. It simply put Oklahoma in the position that a state like Arizona is in. But it still was a big problem, just in pure numbers. The McGirt case talks a little bit about the disruption that would occur, but said, well, you know, that can be handled. Other cases have caused disruptions, and they eventually get to be handled. It was a lot bigger than most disruptions. But part of the burden was lifted 2 years later by the next Supreme Court surprise. And that was Oklahoma against Castro Huerta, decided just last year. And here is Justice Kavanaugh writing, joined by the Chief Justice and Justices Thomas, Alito, and Barrett. Well, the issue in that case involved a crime by a non-Indian against an Indian that in the past would have gone to federal court. It couldn't have gone to state court. And Justice Kavanaugh said, well, it's true that ever since it was passed in 1834, the General Crimes Act, which I usually call the Indian Country Crimes Act because it's more expressive, covered crimes by or against Indians when the other party was a non-Indian. In other words, sort of cross-political crimes, and they went to federal court under the Indian Country Crimes Act, or the General Crimes Act. And that was thought to be exclusive. In other words, there wasn't the option of sending those cases to state court. And again, all of us who taught Indian law and have been looking at the statute since 1834, I'm not quite that old, had been assuming, of course, it's exclusively federal, because at the time the 1834 Act was passed, relationships between the tribes and the non-Indians were clearly federal. I mean, that was the whole design in the early days of the division of authority. And here we had crimes by non-Indians against Indians or by Indians against non-Indians. Well, Justice Kavanaugh says there's nothing in the terms of the statute itself which just extends federal law into Indian country that talks about whether it is exclusive of the states. Of course, at the time it was passed, it didn't have to be. Nobody thought the states would have jurisdiction of such crimes. But nothing in there says that. So he can't find anything saying, well, this must be exclusively federal. He also looks at it from the state side, and he says, the states are sovereign too, and you can't say the way John Marshall did that state law cannot penetrate Indian country. John Marshall said that the laws of Georgia can have no force in Indian country in Georgia. And Justice Kavanaugh looks at that and says, well, you know, that's been watered down. We now recognize that state law does go into Indian country. And he cites a couple of cases which indeed do hold that. But those are cases where a non-Indian was committing a crime against a non-Indian. The first one was, they're both come in the 1880-90 area. And the court looking at that, when the Supreme Court looked at that case, they sort of said, well, one guy murdered another guy, they're two non-Indians, and it turns out they're in a corner of the Ute Reservation. What's that got to do with the Indians? You know, there's no reason that has to be a federal crime or anything. The state can have it. And those are the two cases for Justice Kavanaugh saying, well, state law is, you know, has force in Indian country. You know, it has force against non-Indians. It's always been confined to that. But anyway, he makes the case for state sovereignty over this territory. And then he says, well, would state jurisdiction interfere with the right of Indians to make their own laws and be governed by them? That's a test from Williams v. Lee, which Dean Leeds mentioned as occurring in 1959 when I was a clerk on the for the Supreme Court Justice. That test said that state law is excluded, state jurisdiction is excluded when it would interfere with the right of Indians to make their own laws and be governed by them. And Justice Kavanaugh says, well, this really doesn't. If we're dealing with crimes by non-Indians against Indians, it doesn't really interfere with Indian affairs, with the tribe's own affairs. So it doesn't violate that. And therefore, since the state is sovereign and it includes all of the state and it has some force in Indian country, it can have force in this case. So not only have I found the Indian Country Crimes Act not exclusive, in other words, it doesn't exclude the states, that's only half the question. Can the states then come in? And he says yes, because they're sovereign, they've occupied this territory before, but it's a big change because the state will be able to come in and pick up crimes by Indians against Indians, which used to be covered by the federal Indian Country Crimes Act. So that is a considerable change. It also, Justice Kavanaugh refers to the McGirt case and the burden it has caused. I mean, he says, I consider us to be having a problem, and this is going to help. And indeed it will. And I'm sure it has. Because let's say 90% of the criminal population of Oklahoma is non-Indian. It's probable that about 90% or something like that of the crimes committed in Indian country were committed by non-Indians. And if that's the case, an awful lot of the people being released from prison in Oklahoma can stay there now because we're holding that Oklahoma, unknown to us at the time, does have jurisdiction over crimes by Indians against non-Indians. Well, I was a little surprised by a panel that was held here in the law school not too long after Kavanaugh's opinion came down. And it was people who'd been working in Indian law. And one of them was my former law clerk, Kevin Washburn, who later became Assistant Secretary for Indian Affairs. And they all seemed to agree on two things. First, almost everything that Justice Kavanaugh said about sovereignty and the state being sovereign over all country, including Indian country, was just awful from their standpoint. And two, the actual results were not particularly disturbing. They said, the sheriff's already in Indian country because he does patrol Indian country for crimes by non-Indians. Victimless crimes or crimes between non-Indians. So, you know, the sheriff still drives by in Indian country. And if he wants to arrest a few non-Indians who are beating up Indians, that's okay with us. So they felt that they can easily live with the Kavanaugh opinion. I was kind of surprised at that. I thought they might say, well, this is just one more encroachment of the state into Indian country, and it is. But on the sort of bottom line, they didn't seem to think that this was going to be a huge day-to-day jerk for the tribes. And that was kind of interesting to me. Well, where do you come out in all this? Justice Gorsuch is clearly the leader in the fight for tribal sovereignty. Every time he gets the chance, he supports it. And he serves a very useful purpose. I mean, he serves two useful purposes. One, he is not at all shy about educating the court or his readers of opinions of the whole history that brought the case to court. The history of what's been done in Indian affairs as a national policy and all of the wrongs it encompassed from time to time. He does that. And everybody knows he feels this strongly. And having him on the court has its influence, just like, a little bit like when Second Justice Marshall joined the court. Thurgood Marshall, just having him at the conference bench has its effect. Justice White once said, when you get a new justice, it's not just a new justice, it's a new court. Because each justice has an effect on his fellows or her fellows. And having Gorsuch there, I think you're going to find year in and year out is going to be a very good influence on the court in the future. Just because he is very eloquent about what happened in the handling of Indians over the last 150 years. So I think the rescue of Oklahoma, the 60 to 90% rescue of Oklahoma's burden probably is working a great deal. I don't know if the federal defenders are still traveling to Oklahoma. They probably are because there's still a backlog. But it's nothing like the problem it would have been. And in the future, of course, it can be handled. Once the backlog's gone, there's nothing about Oklahoma that isn't much different from Arizona, and they can handle things in the same way. Can Justice Gorsuch attract a majority in any given case that comes up? Hard to say. The majority he had in McGirt included Justice Ginsburg, Justice Ginsburg has been replaced by Justice Barrett. Justice Barrett was helpful in the main part of the Indian Child Welfare Act case, but she's not necessarily part of what we used to call the liberal group on the court, a rough term that, of course, doesn't always accurately describe the members. But he has been in his minority in several cases since. He was in the minority. He dissented. I'm sorry he was in the minority. He dissented largely, joined by Justices Sotomayor, Kagan, and Jackson. 3 more, not quite enough. In the very recent case which said the Navajos are not entitled to go to court to get the United States to give an accounting of its trusteeship of Navajo water, much of which is the Colorado, the Little Colorado, or one other river that feeds those streams. The Ninth Circuit has said the United States owns that water. They really have a duty not just to account, but also to see that the water can get to the tribe and be useful. And the Supreme Court, capital law writing, said no, there's no duty to deliver the water and the waterworks that are needed to deliver the water. It's enough that the water is held in trust for the tribe. That seems to me to be a huge stretch, especially when the tribe, one of the things the tribe's asking for is just an accounting. How much water is there that's ours in the Colorado? That's never been quantified. There is pending litigation. As one of the lawyers here can tell you, for the Navajos to get a quantification. But it would be nice to know how much we've got. There's a lot of uproar about the Colorado River right now. And the federal government is likely to step in as the water levels fall lower and lower and make its own allocation, which is frightening everybody. A lot of the old appropriators, and the tribes necessarily are old appropriators. They have a priority date way, way back. But we're all concerned about what happens when the secretary steps in. Well, we'd like to know what he thinks he's dealing with, what he's dealing with, or she is dealing with, and that's she now, with Navajo waters. But anyway, he was in the Florida centers in that case. He dissented all by himself in a bankruptcy case, which also is in the last couple of years. And the question was, did the Bankruptcy Act abrogate tribal sovereign immunity? The tribe had lent money to a guy. He went bankrupt. It was thrown into bankruptcy. The bankruptcy courts administering in the state, the tribe, it's an instrumentality, it's not the tribe itself, kept pressuring, trying to collect this debt from the debtor who's now in bankruptcy, which normally stays actions against the debtor while the bankruptcy is going on. So the bankruptcy court issued an injunction against this tribal entity saying, stop pestering this. We don't want you to get priority over other debtors. Stop pestering. And the court got the case, well, did the Bankruptcy Act, which abrogated tribal immunity, tribal sovereign immunity, do so by a paragraph that said governmental structures are, governmental organizations immunity is abolished, including, and then it listed lots of different kinds of states, cities, corporations and things. And then it added, or other foreign or domestic organizations, governments, or other foreign or domestic governments, because we're talking about governmental immunity. And the argument that the court looked at that and said, that's really inclusive. And there are reasons why it's inclusive, which I'll get to in a second. Justice Gorsuch says, well, we've got a rule that to abrogate tribal sovereign immunity, you've got to be explicit. And here's a statute that lists all kinds of people whose immunity, all kinds of governments whose immunity is being abrogated, and it never says tribes. And that suggests the tribes really aren't covered. And everybody knows our position that to abrogate the immunity of tribes, you got to be specific. It doesn't say you have to name tribes, but you do have to be specific. And he says they weren't specific, so the tribe immunity is not covered. What I don't think that he discusses adequately is a point that the majority, Justice Jackson, does make. What are we trying to do in bankruptcy? We're trying to take an insolvent estate, the property of this bankrupt, and handle it in such a way that each creditor gets his or her share of what's left. And if you have one creditor who's not in the mix, not within the jurisdiction of the bankruptcy court, bankruptcy won't work. That creditor will be able to, grab the estates of the debtor and pester the debtor until they pay and make life miserable and so on. And that doesn't leave us with a functioning bankruptcy system. And I don't think that Justice Gorsuch pays enough attention to that. It seems to me one thing to do in determining what Congress intended when you're considering one alternative against another alternative. What makes the thing that Congress is regulating work? And is the statute capable of being interpreted in a way that furthers that purpose? And it seems to me, I think Justice Jackson has this. She said the whole idea of a bankruptcy is to be inclusive. And it listed a lot of organizations. And then other governments, foreign and domestic. And that can include Indian governments and their subdivisions. She says maybe it wouldn't have to, but the whole idea here of this statute is the inclusion. So the intent of Congress must have been to abrogate the immunity of the tribes. On that mere question of interpretation of congressional intent, I'm on the side of the majority on that one. I don't think bankruptcy can work if one debtor is not in the mix. One creditor. I think you know now what some of the recent discussions are in the court, and maybe what I think about some of the questions of tribal sovereignty. Tribal sovereignty is going to be the subject of court decisions for the next several years. Plenary power will too, but that can probably be settled in way by a decision or two that will handle things. I think the problems of state sovereignty and tribal sovereignty are going to go back and forth for a long time. And I don't think that battle is over. I think you're going to be reading cases a decade, 2 decades, 3 decades from now that are still wrestling with the problem. I'd like to, in closing, bring up one other thing about the Supreme Court's treatment of Indian country. I think many of us feel that because the court doesn't get a whole lot of Indian law cases, this recent 2 or 3 years, incidentally, is quite an exception. There always are 1 or 2, but they're not big cases like the last several years have had in the Supreme Court dealing with Indian law. And because they don't get it very often, it's often new to them, and we wonder whether sometimes they're so removed from Indian country they really don't know what's going on out there in Indian country. Justice Gorsuch is an exception to that because he's been on the 10th Circuit, and he is a Westerner, and he had several Indian law matters, and he made it a priority to find out about Indians and Indian law and what's going on in Indian country, and he had some long-term cases that he had to manage. So he learned a lot, and it stayed with him. I want to tell the story about a case it's more like a decade old, or maybe 2. It's called Nevada against Hicks. And this was an opinion by Justice Scalia, and it was joined by several members for various reasons, but it's a kind of a fun case. It involves the state game enforcement personnel, game wardens basically, who thought that an Indian on the reservation had illegally taken mountain sheep, a protected strain of mountain sheep, off reservation, shot him. And they were sure that he had evidence of that. He liked to mount heads of game that he had. He did some guiding, incidentally. So we want to search his house on the reservation, on trust land. So they went to state court and they said, give us a search warrant. We have reason to think, somebody's seen a head up there, that he has evidence of this crime in his house on the reservation. And I've always told my students that everybody behaved very well until this case got to the Supreme Court. Because the state judge said, oh, all right, I'll give you a search warrant. But of course, my writ doesn't run to Indian country, so you have to take the search warrant to the tribal court and get them to approve it if you want, or get a new warrant from them, because this warrant won't do the trick. So they went to the tribal court. They got a search warrant from the tribal court. They took some tribal officers with them. They went up and searched this guy's cabin, and they didn't find any evidence of crime. So they went home. Then about a year later, one of the officers, for some reason, was in that area, and maybe he just snooped or something, but anyway, he said there were reports that this guy had 2 nice mountain sheep heads mounted in his cabin now. And they said, well, now we think we've got the evidence, and one of those is going to, or at least one of them is going to be a protected type of mountain sheep. So we're going to search again. They went back to the state court. State court gave them a search warrant, knowing what they're going to do. He didn't condition the warrant, but they knew what to do. They went to the tribal court. They got another search warrant. They took the tribal police with them. They went up to search this guy's cabin, and they looked at the heads and, no, those aren't protected sheep. So it was another unsuccessful search. But they damaged one of the heads, according to Hicks. So he sued the officers in tribal court. And that's the case that got to the Supreme Court. And they said, well, the tribal court didn't have jurisdiction over this case. It was a tough one to maintain tribal jurisdiction over the state officers. And that's not what I'm dealing with here. The issue is the opinion that the Supreme Court wrote. Scalia wrote the majority opinion, and he made it perfectly clear. He said, the reservation is part of the state. It's a little bit like some of the language Justice Kavanaugh used in the recent case I just talked about. Indian country is part of the state. State officers are dealing with a crime off country, outside of Indian country. It's a crime they're entitled to pursue. An Indian country is part of the state. They can pursue where they need to. They can go to Indian country. The search warrant they got from the tribe was utterly unnecessary. He says that in his opinion. So his view is, well, it was nice of the officers to stop and get a warrant from the tribal court, but they didn't have to do anything. They didn't have to do anything but get a search warrant from the state court, even though the state court tells them, you know, my rate doesn't run to Indian country. And then they can go in and search. On trust land, in the reservation. Well, that attitude, of course, would apply to arrests. If there's a crime committed off reservation by an Indian, he can go back to his house in the reservation. The state officers can just, a few days later, go in and arrest him. They don't need to stop at the tribal headquarters. They don't need a tribal warrant. They don't need to bring the tribal police with them. They can just go in and arrest him. Well, that's just a staggering proposition, but that's the case. Justice O'Connor wrote a very severe criticism of that part. She was concurring for other reasons about jurisdiction of the tribal court, but she really criticized very heavily that, and she was joined by Breyer in doing so, and Stevens at the time. Well, I gave a talk a few years after that case to a group actually it was at the old law school, and it was people who had been working in Indian law, some enforcement people and others. And I said, you know, I've been around to a lot of the tribes since then, and I've talked to some of the tribal judges and even a couple of police chiefs, and they said that the state officers are ignoring Hicks. If they want to search or arrest somebody here, they always seem to stop by the tribal headquarters, and they talk to the tribal judge and they get his approval, and then they take a couple of tribal officers with them. And after I finished the talk, and included some other things, a state trooper in uniform came up to me afterwards and said, boy, I'm glad you said that and that. He said, of course we always notify the tribe when we're going into the tribal territory. Of course, if we're going to search or arrest, we go to the tribal court and get authorization. Of course, if we're going to do it, we take tribal officers with us for two reasons. One, we don't want to get shot. It's you go knock on somebody's door, or you bust into it and arrest somebody in the middle of the night, and they don't know who you are, you might get shot. And he said, even more important, we have a lot of enforcement issues. There are a lot of, we've got the Gila River and the Salt River edge right on the edge of Phoenix. There are plenty of non-Indians going in and committing crimes on there. We have policing problems. We also have probationers who are convicted of crimes off reservation and they go back to the reservation to live. Who's going to monitor that probation? The tribal authorities will do it because we have cooperative agreements with them. They need us. when they want to put somebody on probation who's going to come back and live in Phoenix. When we want to have highway checks, and near or in Indian country, that's sometimes going to involve stopping both Indians and non-Indians. We can't just do that by ourselves. We have to, we don't live in separate worlds. We need their cooperation and they need ours. So I'm happy to say that Hicks is just a bad dream in almost every place in the country. It's there. And I suppose once in a while, if you get a renegade sheriff or something, he can say, hell, I don't need a warrant, I'm just going in. But that's not what, I don't know of any who do that. And that's just kind of a nice postscript that what's going on the ground is sometimes more important maybe than what even the courts say. The final note I have is what's going on the ground in Indian country now, of course, especially since Indian gaming, but even without it, is a huge amount of development. The tribes, if you go into one of the tribal headquarters now and compare it to what it looked like when I first looked 60 years, about 60 years ago, there's no comparison. I can go into the tribal courts of Gila River, Salt River, or many others around the state. That courthouse I'm going into is just as good as the courthouse of most of the outlying cities in Arizona. Their firehouses are built for once finally likely to be close to the fire instead of waiting for something to come long distances away. And there are all kinds of enterprises. There are all kinds of businesses there. And I mention this because there are a lot of people here who are in the Indian law program. They're going to be graduates. They will, many of them, practice what they hope is Indian law. And I wish them well in that. And there's plenty to do in Indian law. But you'll have to know that Indian law, if you go and be an Indian lawyer on the reservation or in connection with reservation activities, you're not going to be just doing Indian law. If you're working for a tribal client now, you've got all kinds of law. There's all kinds of economic development. That involves a real estate business. It involves dealing with sovereign immunity. It's often decided to waive, the tribe can waive sovereign immunity if it wants to get financing in certain circumstances. And then there are just the practical problems any business has. So what you're looking forward to is a practice, if you deal a lot with Indian affairs, a practice that's not just a lot of Indian law, which you are uniquely qualified to deal with, but also all the other law you're learning in law school, you'll find comes into play on an Indian reservation. That future is very different from what practice of Indian law used to be. Well, good luck in it. Thank you very much. I wish you well.
Okay, stay up here, Judge Canby. We want to honor Judge Canby for his 56 years of service to ASU, to the Indian Legal Program, to Indian law in general, and we're going to honor him by giving him this blanket, just to let him know how much you mean to us, Judge Canby, and appreciate you.
Well, I'll be warm for the night.
Yeah.
Thank you. Wonderful.
Here, stand up here. Let's move over here. Let's move over here. Judge Canby is a hunter, so he can bring his blanket hunting with him.
Pardon?
You can bring your blanket hunting with you.
Yes, I will.
Yes. Thank you all so much for joining us. Thank you for sharing your perspective, Judge Canby, your time. We really appreciate you. Please join us on the 5th floor where we have a reception in honor of Judge Canby. It's in 544 and in the courtyard, so thank you very much.